can! Yes, as we all know, Christmas is just around the corner, and what better way to prepare it is... Well, no, what better way to celebrate it, rather, is to put up our Christmas tree and, of course, wear our fancy Christmas hat. So after Christmas is definitely gonna be a new year, and a lot would probably be, dami kong probability, so a lot would probably be venturing into new business opportunities or live on their own. Especially sa mga millennials dyan, I'm sure ang daming gustong mag-live on their own in that new city kaya or new country. Wow, new country. So yes, so in this vlog, we're gonna be sharing to you some insights, some lessons, and jurisprudence with regard to contract of lease. So yes, wag na nating patagalin pa. Here it is.
One eternity later.
Oh yes, before I forget, here are 5 shoutouts from the highest court of the land, the Supreme Court. Starting off with Rodriguez versus Borromeo. Yes, the Supreme Court held with regard to the dissolution of conjugal partnership, lease of conjugal property, that upon the dissolution of the conjugal partnership with the death of the wife, the husband becomes the administrator of the conjugal property and continues in such capacity until the said partnership is finally liquidated, and as such administrator, he may before said liquidation lease without judicial authority the conjugal property for a period not exceeding 6 years, even if a portion of the property so leased may possibly belong to the deceased wife. Yes, Article 1548 of the Civil Code, which fixes in 6 years the maximum period for which an administrator may lease conjugal property, is general and applies to a judicial administrator or an administrator of a deceased property as well as to one of conjugal property. And number 2, Melancho versus D. The Supreme Court held, with regard to community of property alteration, that Article 397 of the Civil Code provides that none of the owners shall, without the consent of the others, make any alterations in the common property, even though such alterations might be advantageous to all. While the property referred to in this case was leased, without the consent of all the co-owners, building thereon 1 house and 3 warehouses, it cannot be considered that the alterations are of sufficient importance to nullify the lease, especially so since none of the co-owners objected to such alterations until over 20 years after the execution of the contract of lease. Also, in addition, with regard to contract of lease and its rescission, the provision in the contract that the lease, at any time before he erected any building on the land, might rescind the lease can hardly be regarded as a violation of Article 1256 of the Civil Code. And finally, annulment. In this case, only a small majority of the co-owners executed the lease here in question, and according to the terms of the contract, the lease might be given a duration of 60 years. This is an open violation of Article 1548 of the Civil Code, and the contract of lease herein in question should therefore be declared null and void. And now, number 3, we have Tipton versus Andueza. Yes, the Supreme Court held with regard to administrator special power that under Article 1548 of the Civil Code, an administrator, in the absence of any special power giving him such authority, cannot enter into a contract of lease with respect to property entrusted to him for a period exceeding 6 years. And number 4, we have Dacuda versus Consolacion. Yes, the Supreme Court held with regard to occupation by respondents of premises by tolerance by property owners without any contract. Ejectment is the proper remedy for refusal to vacate premises. A person who occupies the land of another of the latter's tolerance or permission without any contract between them is necessarily bound by implied promise that he will vacate upon demand. Failure of such would result to a summary action for ejectment, and that is the proper remedy against him. The status of the defendant is analogous to that of a lessee or tenant whose term of lease has expired but whose occupancy continued by tolerance of the owner. The proper remedy against the person who occupies such land of another who has no contract with the owner and whose possession is merely tolerated but who refuses to vacate despite demand is the summary of action for ejectment. Yun po yung proper remedy. And finally, number 5, Taco versus CA. The Supreme Court held with regard to the transfer of lessee's rights over the lease contract of a parcel of land to an assignee, with the latter assuming all the obligations of the lessee under their contract is an assignment of the lease, not a mere sublease of the leased premises. In this case, the Supreme Court said that it is to be noted that the private respondent transferred not only all rights over the lease contract, but the assignee assumed all the obligations imposed on the lessee in said contract. It is clear that the intention was for the lessee to disassociate himself completely from the lease contract he had entered into. This agreement is an assignment of the lease and not a mere sublease of the leased premises. And in addition, assignment of contract of lease without the consent of the landowner does not constitute by itself a ground for rescission of the contract, but may be a justification for filing an action for its rescission by the owner. No liability for damages.
Só que a profissão das minas é...
Abusadamente ela vai bater, bum, bum, ela vai sentando, bum, bum, ela vai quicando, bum, 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 ela vai bater, bum, bum, ela vai quicando, bum, ela vai sentando, bum, bum, bum.
Abusadamente ela vem batendo.
Wheelers International versus Bonifacio, GR number 139540. Facts of the case. The co-owners, comprised of the board of directors of J&R Bonifacio Development Corporation, known as JRBDC, own a parcel of land in EDSA, Mandaluyong City. On May 5, 1994, Bonifacio Development Associates Incorporated, known as BDAI, represented by Jaime Bonifacio as the president and chairman of its board of directors, entered into a contract of lease with Wheelers for a term of 5 years from June 1, 1994 to May 31, 1999. On May 31, 1994, JRBDC, represented by the co-owners as members of the board of directors and lessors of the property, entered into a lease development agreement with BDAI. Under the lease development agreement, BDAI was authorized to renovate, manage, develop, and sublease the property. The term of the agreement was also for 5 years, from May 31, 1994 to May 31, 1999. On the same day, the co-owners executed a general power of attorney in favor of Jaime, granting him the authority to administer the property, renovate the building, introduce improvements, and lease the property to any person. On August 18, 1996, the co-owners as directors of JRBDC approved a resolution terminating the authority of Jaime Bonifacio to manage and administer the property due to BDAI's failure to submit an accounting of the income from the property. On January 26, 1997, the co-owners as members of the board of directors of JRBDC approved a resolution appointing Jovito as the new administrator of the property. The following day, Rosario wrote a letter informing Wheelers about the appointment of Jovito as the new administrator of the property and the termination of Jaime's authority to manage the property. On March 4, 1997, Jovito wrote to Wheelers claiming that the co-owners did not authorize the contract of lease between BDAI and Wheelers. Jovito gave Wheelers 10 days to vacate the property. Meanwhile, Wheelers continued to pay BDI a monthly rentals from February to September 1997. On October 9, 1997, Jovito and the other co-owners, through counsel, sent a letter to Wheelers demanding payment for the rentals and arrears from February to October 1997. The letter also demanded that the Wheelers vacate the property within 5 days from the receipt of the letter. The issue of the case: whether or not the sublease agreement between BDAI and Wheelers is valid. The Supreme Court held it is valid. BDAI is a subleasor of the property. BDAI sublease agreement with Wheelers is within the 5-year term of BDAI's principal lease with the co-owners. Until the expiration of the 5-year term of BDAI's principal lease, the sublease agreement between BDAI and Wheeler remains valid unless the sublease agreement is judicially annulled in the proper case or unless there is a judgment canceling BDAI's principal lease with the co-owners or ousting BDAI from the property. Moreover, no lease agreement exists between the co-owners and Wheelers. Therefore, Jovito's claim that the term of the alleged lease agreement between the co-owners and Wheelers has expired has no legal basis. Blas versus Court of Appeals, GR number 82813. Facts of the case. Petitioner Emilia Blas was a lessee of the Premier Theater building, which was owned by Alfonso Bichara. Petitioner's contract of lease with Bichara gave her the right to sublease the premises and was originally effective for a period of 5 years from January 1, 1980 to December 31, 1984. Petitioner Blas in turn entered into an oral contract with the private respondent, Arthur Yao, subletting the latter a portion of the premises. On March 27, 1985, Bichara wrote respondent Yao informing the latter that since the contract of lease between Bichara and the petitioner Blas had expired on December 31, 1984, the rental due from respondent Yao and accruing from January 1985 and thereafter were to be paid to Bichara. Bichara then filed an ejectment suit against petitioner Blas before the MTC. The MTC rendered a decision dated November 11, 1985, extending the petitioner's Blas lease contract with Bichara for another 5 years, counting from January 1, 1985 up to December 31, 1989. Upon appeal by Bichara, the RTC affirmed the decision of the lower court, and that decision became final and executory on July 2, 1986. Blas then demanded that Respondent Yao pay to her the accrued sublease rentals. Respondent Yao, however, continued to remit his sublease rentals directly to lessor Bichara. In a letter dated February 7, 1987, petitioner demanded that the Respondent Yao pay the accrued rentals pertaining to the portion of the premise originally subleased to him, which led to an ejectment suit against Yao. Yao argued that he was not defaulted on the payment of sublease rentals, since he had been paying the same to the lessor Bichara, who in turn was crediting petitioner with the amounts thereof. Issue of the case: whether or not Respondent Yao had incurred default in the payment of sublease rentals. The court held Yao was in default. In a sublease arrangement, there are two distinct leases involved, the principal lease and the sublease. There are two juridical relationships which coexist here and are intimately related to each other, but distinct from one another. The payment by sublessee Yao to lessor Bichara was not payment to the petitioner's sublessor Blas. Bichara was a stranger to the relationship between sublessor Blas and respondent sublessee Yao. Respondent Yao was not entitled to ignore the rights of petitioner Blas. He had no right or authority to pay the sublease rentals to lessor Bichara, the said rentals being due and payable to sublessor Blas. We conclude that Respondent Yao was in default vis-a-vis the petitioner Blas in the matter of payment of the sublease rentals, and that accordingly, petitioner was entitled to terminate the sublease agreement for failure of Respondent Yao to pay the sublease rentals due.
Good morning, everyone. This is the case of Arminda Florentino versus SuperValue Incorporated, GR number 172384, September 12, 2007. Petitioner is sole proprietor engaged in the retail of empanada, executed 3 contracts of lease with respondent, a domestic corporation engaged in leasing stalls inside SM malls. The term of each contract is for a period of 4 months and may be renewed upon agreement of the parties. The contracts were extended, and before its expiration, petitioner received 2 letters from respondent that she violated the contract and it will no longer be renewed. Respondent instead took possession of the store space in SM Mega Mall and confiscated the equipment. An action for specific performance, sum of money, and damages was filed by petitioner after respondent refused to release the equipment. The RTC decided in favor of petitioner. The Court of Appeals modified the RTC judgment and found that the respondent was justified in forfeiting the security deposits and was not liable to reimburse the petitioner. Issues: whether respondent is liable to return the security deposits to petitioner, and whether respondent is liable to reimburse the petitioner for some of the improvements she introduced in the lease premises. The ruling: petitioner cannot therefore rightfully demand the return of the security deposits, for it is deemed forfeited by reason of contractual violations. Provision in the contract of lease mandates that she should first obtain respondent's consent, and in this case, she did not secure the consent of the respondent. Since petitioner's interest is that of a leasee, she cannot therefore be considered a builder in good faith. The respondent may appropriate the improvements without any obligation to reimburse the petitioner. The court ruled that there is basis for respondent's refusal to return to petitioner the security deposits. Petition partly granted. The case of Pedro Bercero v. Capital Development Corporation, GR number 154765, March 29, 2007. The facts: Capital Development Corporation leased its commercial building on lot to R.C. Nicholas Merchandising for a 10-year period with the option for the latter to make additional improvements and to sublease portions thereof to third parties. R.C. Nicholas converted the rented space and subleased separate portions thereof, including petitioner, for a period of 3 years. R.C. Nicholas filed a complaint for ejectment in collection of unpaid rentals against petitioner, and the MACC ordered the eviction of petitioner. Petitioner made repeated demands on respondent for the restoration of his possession of the commercial space leased to him. The issue of the case: whether respondent as lessor is obliged to restore petitioner in his possession following his eviction from the premises. The Supreme Court ruled no. The lease contract between petitioner and respondent is void because respondent did not have the right to lease their property to petitioner, considering that its lease contract with R.C. Nicholas was still valid and subsisting, although pending litigation. When petitioner entered into a lease contract with respondent, the latter was still obliged to maintain R.C. Nicholas' peaceful and adequate possession and enjoyment of his lease for 10-year duration of the contract, as stated in Article 1664, Paragraph 3 of the New Civil Code. There is no merit to petitioner's claim of good faith in dealing with respondent. Petition denied.
Future, take my hand and guide me. When you are beside me, I'm strong. And thank you for all that you have done.
Gaudencio Simpao versus Joaquin Dizon, GR number 452, April 30, 1902. Facts. Simpao alleged in his complaint that he was the sole owner of the 2 parcels of land and that he had been in possession of said lands since June 1888, having acquired the same at said time from Gaudencio de Mesa by sale with right of repurchase. He leased it to Cecilio Laksamana, who has been cultivating the premises during the last 2 years, but on account of the unsettled condition of affairs, landowners could not take case of their property and that the defendant Dizon had taken possession of the land. Laksamana shows that the plaintiff was in possession through him and that he was dispossessed of the property by the defendant. The only admissible evidence in the summary proceedings is in reference to Article 1634 of the Old Code of Civil Procedure, which states that a claimant was actually in possession or tenancy of the property and he had been molested or disturbed in such possession or tenancy by the defendant. Issue: whether the action can be maintained by Simpao in the recovery of the land. Ruling: the court ruled that unquestionably he has a right to maintain the action to recover possession of the lands, otherwise he might lose his civil possession and suffer serious inconvenience. Article 1654 of the new Civil Code relates to the rights and obligations of lessor and makes it the duty of the lessor to maintain the lessee in the peaceable enjoyment of the lease for the entire duration of the contract. By Article 1559 of the Civil Code in this case, states that the lessee is bound to give notice to the owner with the least possible delay of any usurpation or injurious alterations which any person may have done or is openly preparing to do to the thing leased. The acts of dispossession were committed by Dizon. Therefore, judgment rendered in favor of the plaintiff. Pedro P. Rojas versus Maria de la Paz Miaras, GR number L3823, November 23, 1907. Facts. A complaint was filed by Pedro P. Rojas praying that judgment be entered in their favor for the recovery from the defendant Maria de la Paz Miaras of the possession of a parcel of land. The plaintiff allegedly was deprived by the defendant of the possession of said extension of ground by means of fraud, craft, and deceit, the latter occupying the same and closing the entrance to it by obstructing the ark and erecting a wall far beyond the place where it formerly stood. That said construction was carried out by the defendant without the knowledge or consent of the plaintiff, her house not having yet demolished. The defendant, Maria de la Paz Miaras, in her answer and as the defense alleged that all the work carried out by her in her own house was done in compliance with orders from Board of Health of Manila. Issue: whether the plaintiff should maintain action in the recovery of possession of the land having deprived of by the defendant. Ruling: yes, the judgment appealed from is affirmed by the court. The fact that the property was leased and occupied by the tenant on May 9, 1905, when the usurpation took place, is no bar to the owner thereof, the plaintiff exercising her right by claiming the restitution of possession of which was deprived by the defendant, inasmuch as the lessee held and enjoyed the property on behalf of the plaintiff, who, according to number 3 of Article 1654 of the Civil Code, is obliged to maintain the lessee in the peaceful enjoyment of the lease for the entire duration of the contract. Paz S. Baines versus Court of Appeals, GR number L57091, November 23, 1983. Facts. Dr. Paz Baines was the lessor and Chua Seng was the lessee over the premises subject to the controversy. The contract was bound by an oral contract of lease. Chua began his tenure as lessee since 1952. On October 1975, Chua left the premises with an intention to return. He padlocked his door before leaving. Upon returning, he found that his door was locked with another padlock caused by Dr. Baines. Dr. Baines refused to remove the padlocks of the door. Chua alleged that Baines' refusal to remove the locks were a breach of contract of lease consisting in the deprivation of plaintiff's right to occupy and use leased premises. Dr. Baines answered that Chua Seng's right to occupy said premises had long been expired and that the respondent failed to pay rentals due and had voluntarily vacated the premises. Issue: whether the contention of Baines was correct that the lease contract between her and Chua has expired, applying 1687 and first paragraph of 1673. Ruling: Baines states that since the rentals agreed upon were paid monthly, then the term of lease should be understood to be on a month-to-month basis. The contract of lease was verbal, it had no fixed terms, and rentals were paid every month. The petitioner contends that PD number 20 covers only leases of dwelling units where the rental is 300 pesos or less a month and therefore does not apply to this case where the rental is 390 pesos a month. PD 20 provides suspension of paragraph 1, article 1673, which governs the termination of contracts of lease which are on a year-to-year, month-to-month, week-to-week, or day-to-day basis. The court ruled in favor of Chua insofar as it restores respondent Chua to the possession and enjoyment of the leased premises.
Rantael versus CA, GR number L-47519, dated April 30, 1980. These are the facts of the case. Respondent Liave and petitioner Rantael entered into a verbal agreement of lease for the latter's apartment, but later on, the lessor sued to increase the rental, which caused Rantael to file a complaint. However, it was agreed upon by the parties to roll back the monthly rent and to execute a written lease contract. In its term, the lease was fixed on a month-to-month basis, and either party may terminate the agreement upon 30 days' notice. Subsequently, Liave notified Rantael of her decision to terminate the lease agreement and requested him to vacate the premises. However, Rantael refused, invoking in his favor Section 4 of PD number 20. Hence, ejectment suit was filed. Issue: whether the lessee may not be judicially ejected based on Section 4 of PD number 20, since the lease is for a fixed or definite period. The court ruled that the contractual relations between petitioner Rantael and respondent Liave ceased after the expiration of first 30 days reckoned from August 1, 1974, but continued for the next 30-day period and expired after the last day thereof. Repeating the same cycle for the succeeding 30-day period until the said respondent Liave exercised her express prerogative under the agreement to terminate the same. By express exception of PD number 20, judicial ejectment lies when the lease is for a definite period, or when the fixed or definite period agreed upon has expired. The lease in the case at bar having a definite period, it indubitably follows that the exception rather than the general rule applies, and therefore, respondent Liave's right to judicially eject petitioner Rantael from the premises may be duly enforced. Gustello versus CA, GR number L-61083, dated February 28, 1983. These are the facts of the case. Private respondent Noemi Viuda de Gustello, as attorney-in-fact for her two sons, leased to the petitioner Daniel Gustello 2 parcels of agricultural land for a period of 10 crop years. The stipulated rental was 500 pesos per crop year, but later on, the parties agreed to increase it to 1,000 pesos per crop year. Subsequently, the two sons sold the lands to their mother. Now, as the new owner, Mrs. Gustello sued her brother-in-law Daniel for collection of rental for the option period in the amount of 20,000 pesos per year. Their contract of lease contains this provision, that the expiration of these 10 crop years of lease, the lessee shall have the option to another 5 crop years. Issue: what should be the rental for the extended period of the lease in the absence of a specific stipulation concerning it? The court ruled that in a contract of lease where the lessee is given the option to continue or renew the contract, and nothing is said about the rental as in the instant case, the old terms are to be followed in the renewed lease. In the case at bar, the stipulated rental in the original contract was 500 pesos, later increased to 1,000 pesos per crop year. Accordingly, the rental for the renewed period should also be 1,000 pesos per crop year.
You are my sunshine, my only sunshine. You make me happy when skies are gray. You never know, dear, how much I love you. Please don't take my sunshine away.
GR number 148562, dated November 25, 2004. The case of Tagbilaran Integrated Sellers Association versus Court of Appeals. This petition seeks to reverse and set aside the CA decision in affirming RTC decision. Let's proceed to the facts of the case. Tagbilaran Women's Club or TWC owned 2,726 square meters, which TWC entered into separate written lease contracts for a period of 1 year with individual petitioners. These petitioners are the people who created and founded Tagbilaran Integrated Settlers Association, who constructed residential buildings and business establishments on the lot owned by Tagbilaran Women's Club. On January 6, 1990, TWC sent a letter to the petitioners demanding to vacate the rented premises on the following grounds. First, the expiration of lease contracts. Second, non-payment of rentals. Third, violations of the conditions of lease. On February 25, 1993, TWC entered into a lease contract on the lot with Lambert Lim, who at once paid a total of 240,000, representing payment of rentals for the first 12 months. Now let's proceed to the issue raised. Whether the implied new lease contract will justify the petitioner's continued occupation of the lot. The court ruled as no. What is the rationale behind the court's decision? According to Article 1669 of the Civil Code, lease contracts having been executed for a determinate time, they ceased on the day fixed. The lease contract executed by TWC and petitioners in 1986 and 1987 were for a period of 1 year. A month-to-month lease is a lease with a definite period. Hence, it is terminable at the end of each month upon demand to vacate by the lessor, according to Article 1687 of the Civil Code. When notice to vacate, dated January 6, 1990, was sent by TWC to petitioners, followed by another dated July 16, 1990, the implied new lease was aborted. For a notice to vacate constitutes an express act on the part of the lessor that it no longer consent to the continued occupation by the lessees of its property. It is clear that they no longer have the right to continue in the possession of the subject lot because their continued stay therein was without the consent of TWC. This is Suzette Pakanan. Thank you for watching. GR number L23399, dated May 31, 1974. The case of Bernardo Dizon versus Ambrosio Magsaysay and et al. Now let's proceed to the facts of the case. Ambrosio Magsaysay, the registered owner of a parcel of land, and Bernardo Dizon executed a written contract of lease, which the latter had been occupying as a lessee for 12 years, and in which he had constructed a residential house as well as a 6-lane bowling alley. The 2-year term of the lease contract expired on April 1, 1951, without the parties having expressly renewed their agreement. Bernardo Dizon continued to occupy the leased premises, paying the same monthly rental of 100 pesos, which Ambrosio Magsaysay accepted. 2 years later, the Council of Ambrosio Magsaysay advised Bernardo Dizon of the termination of the existing lease at the end of the month. On March 11, 1953, a new certificate of title was issued to Nicanor Padilla pursuant to the sale of the entire lot. Let's proceed to the issue raised. Whether or not Bernardo Dizon has the preferential right to purchase the said property with the same price and terms given to Nicanor Padilla. The court ruled as yes. What is the rationale behind the court's decision? As stated in paragraph 2 of the contract of lease of the parties, it was renewable for the same period of 2 years, upon its expiration on April 1, 1951. The stipulation embodied the agreement of the parties with respect to the renewal of the original contract, and while there was nothing in it which was incompatible with the existence of an implied new lease from month to month under the conditions laid down in Article 1670 of the Civil Code. Such incompatibility existed with respect to any implied revival of the lease's preferential right to purchase, which expired with the termination of original contract. On this point, the express agreement of the parties should govern, not the legal provision relied upon by the petitioner. This is Suzette Pacanan. Thank you for watching.
Ho, ho, ho! Merry Christmas!
Merry Christmas, everyone. This is Saludela Nasabero, and I will be reporting the case of Choice Power Realty Corp versus CA, GR number 113626 of 2002. The facts of the case. The controversy springs from an apartment building owned by Jurisprudence Realty Corp. The said corporation was led by its president, Jesus Oy, and executed a contract of lease with her respondent, Santi and Kotong. Pursuant to the said contract, Santi occupied the room 217 and said building at a monthly rate of 814, while Santong occupied the penthouse at a monthly rate of 917. The contract of lease explicitly stipulates that the lessees may occupy the said premise as long as the payment for monthly rentals is updated. The lessees may terminate the contract anytime provided that they give a 60-day priority notice. The lessor may terminate the contract anytime should the lessees commit a violation of the terms of the agreement. For 5 years, the lessees were able to pay petitioner corporation religiously. However, on January 1990, the petitioner sent them a letter asking for an increase in the monthly rate. From a price agreed 800 to 900, it became 3,500 for each of them. In reply to the said proposal, the respondent through their counsel sent a letter of opposition to the said proposal. Due to the opposition, the petitioner corporation filed an ejectment case against the respondent, also ordering them to pay 7,000 for monthly rental on February and March in 1990. Respondents gave extra effort to pay the petitioner according to the original price agreed in the contract. However, it refused. May 1990, the respondent lessee refused the MTC to consign their payment for monthly rentals, and MTC dismissed the ejectment case filed by the petitioner. On February 1991, the judge issued an order allowing her respondent to deposit with the City Treasury in Manila the rentals for 13 months from the date of the filing of the consignment, which is February 1990 to January 1991. Jurisprudence appealed to the RTC, which became in favor of the said corporation. CA reversed decision of RTC, hence this petition. The issue of the case is whether petitioner claims that the contract of lease entered into between the petitioner and private respondents did not provide for a definite period. Hence, Article 1687 of the new Civil Code applies. It was held that no, the Court of Appeals opined otherwise. It reasoned that application of Article 1687 in this case is misplaced because when there is a fixed period for the lease, whether the period be definite or indefinite, or when the period of the lease is expressly left to the will of the lessee, Article 1687 will not apply, citing the case of Eliziki versus Manila Lawn Tennis Club. We agree that the ruling of the Court of Appeals in Article 1687 finds no application in the case at bar. The lease contract between petitioner and respondent is with a period subject to a resolutory condition.
Ho, ho, ho! Merry Christmas!
Thank you for listening. Hi, this is Abuero again. Let us now listen the story of Santa about the case of Eleziki versus the Manila Lawn Tennis Club, GR number 967, May 19, 1903.
Hello everyone. This is Santa. Let me tell you a short story. Ho ho ho. The facts of the case. A contract of lease was executed on January 25, 1980 over a piece of land owned by the plaintiff's Elias lessor to the Manila Lawn Tennis Club, an English association represented by Mr. Williamson for a fixed consideration of P25 per month and accordingly to last at the will of the lessee. It appeared that the plaintiffs terminated the lease right on the first month. The defendant is in the belief that there can be no other mode of terminating the lease than by its own will, as what they believe has been stipulated. As a result, the plaintiff filed a case for unlawful detainer for the restitution of the land, claiming that Article 1569 of the Civil Code providing that the lessor may judicially dispossess the lessee upon the expiration of the conventional term. The lower court ruled in favor of the plaintiffs on the basis of Article 1581 of the Civil Code. The issue of the case is whether there is a conventional term or duration agreed upon in the contract in question. The ruling of the court is no. The system of the code is that of establishing general rules applicable to all obligations and contracts, and then special provisions peculiar to each species of contract. In no part of Title VI of Book 4, which treats of the contract of lease, are there any special rules concerning pure or conditional obligations which may be stipulated in a lease. Because, with respect to these matters, the provisions of Section 1, Chapter 3, Title I, on the subject of obligations, are wholly sufficient. This case is in relation to Article 1687 of the new Civil Code. Thank you for listening to my short story. Ho ho ho. Merry Christmas everyone.
Wow, we've finally reached the end of this vlog. On behalf of High Five Vlogs, we would like to thank you for staying with us. We wish you a Merry Christmas and a prosperous New Year. We hope you'll remember a thing or two with regard to the insights, lessons, and jurisprudence on contract of lease. And most importantly, don't forget to disinfect, wear a mask when you have to go out, and observe physical distancing. And most importantly, stay at home as much as you can and stay safe and healthy. This has been Ken. See you on the next vlog. Goodbye!
Merry Christmas and happy holiday. This season may we never forget the love we have for Jesus. Let me be the one to guide us as another New Year starts. And may the spirit of Christmas be always in our hearts. Let's sing Merry Christmas and happy holiday. This season may we never forget the love we have for Jesus. Let me be the one to guide us as another New Year starts. And may the spirit of Christmas be always